Well, Marc, thanks for joining us today. I don't know if this is a show or a podcast or what we're really calling this. I think it's just like a video thing. So for the
All right.
record, thank you for joining us on this video thing for social
My
media.
pleasure.
Hey, I want to talk to you about Karen Read. So you
Yeah.
first flagged this situation, this case for me about a year ago. And it's inspired a lot of debate across the country. So what's going on?
This is my windmill, I guess, because it's what we've had this very high profile murder trial. And I take no position on whether Karen Read actually killed her boyfriend or if she's innocent or not, but there are a lot of people with very strong feelings about it. Um, and it has become a cause celeb here in Massachusetts. The trial court judge is unusual. Seems very from somebody who does not care one way or another if Karen Read is convicted or not. When I look at this trial, I don't see an impartial judge. I see a judge who is really, really hell bent on getting a conviction here, and has made some strange decisions in that regard. And so let's give her the benefit of the doubt. It's because she somehow knows that Karen is really guilty and we got to get this cop killer put away. And let's not presume any other ill intent. She's also, though, doing whatever the Commonwealth asks her to do with respect to suppressing free speech. So Karen Read was originally tried and it was a hung jury. But during that trial, she imposed a 200-foot buffer zone around the courthouse where you could not demonstrate in any way. And we challenged that. We challenged it before her, seeking to intervene. She quite angrily said that you're not allowed to intervene in a criminal case. And she's not entirely wrong. The court could have probably taken our suggestions under advisement, but she didn't. She made sure to say she wasn't going to do that. The Massachusetts Supreme Court upheld that restriction. Now, we challenged it on two different grounds. One, that it violated the First Amendment, and two, that this judge does not have power outside of the courthouse to suppress the First Amendment, even if she's doing so in a reasonable way. The Massachusetts Supreme Court was really strange in its order because it just flatly refused to address the question of the judicial power, whether it was an ultra-virus act or not. Just completely ignored that question. We moved for reconsideration, asking them to consider that question. They refused to do that. They were just like, la, 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 with a Boston accent. I can't hear you. And then they didn't do anything. They then engaged in First Amendment analysis, which, I know they're the Massachusetts Supreme Court. They're supposed to be smarter than me, but I think they were dead wrong. But what's also funny is they put in their order, and this is called the Spicuzza case. In the Spicuzza case, they specifically put in their order that we are specifically not analyzing the issue of whether this applies to the public sidewalks because that's not in the record. You could have been drunk looking at this record and you would have seen that it was, but hey, if they say it's not in the record, it's not in the record. So defeated, we slunk off to our corner to fight another day. Hung jury, guess what? We got another shot at this. So the Commonwealth asks for a bigger buffer zone. The judge grants it. And now we're challenging it in federal court. I'm kind of thinking maybe a federal judge will look at this and say, yeah, we've got to think about whether or not the judge has power. And maybe the court won't be able to miss the fact that the sidewalks, there's not a magic 200-foot zone around a courthouse that doesn't have sidewalks. The judge that we initially pulled, so we brought this on behalf of three categories of people. We brought it on behalf of people who wanted to demonstrate. Those people have been standing in front of that courthouse for months, since November, holding up signs that say Judge Canone is corrupt. Judge Canone is incompetent. I take no position on the veracity of their protests, but they have every right to do that. She has now banned them from being there doing that. So we brought suit on their behalf, pointing out that the Spicuzza court did not analyze the public sidewalks, pointing out the lack of power issue, and pointing out a lack of due process with respect to impacting their rights without them having a notice and an opportunity to be heard. That's the 14th Amendment. I kind of thought in a liberal jurisdiction like the District of Massachusetts that I could maybe explain to the court that, if you've got a problem perhaps with immigrants being whisked off to third countries without notice and an opportunity to be heard, you might recognize the problem here. The judge did a couple of very strange things. First, like I said, we brought this on behalf of protesters. We also brought it on behalf of journalists who the police have been harassing in that zone. And then we brought it on behalf of Mr. Delgado. And Mr. Delgado was simply walking through the zone with a sticker on his shirt that said, "Justice for John O'Keefe, free Karen Reed." And a masked state trooper went up to him and said, "That's got to go," and ripped it off of his jacket. So now we have the Fourth Amendment as well as the First and the 14th Amendments. These cases are all very related. We filed them as related cases. They're before this one judge, and then the judge decides they're not really related. They're different issues. So it's now splintered to 3 different judges. Tell you, man, civil procedure class could never have prepared you for this.
This is like a law professor's dream, right?
Only a sadistic civil procedure professor could have cooked this up. So we have in the protester case, the first judge says, "I'm going to rely on the Spaguzza court and say that this is completely First Amendment permitted. You can just shut down anything you want outside the courthouse." He also said there was a notice and an opportunity to be heard because some business owners down the street sent an unsigned letter to the court, and Judge Canone considered that. So, I find that kind of strange because, hey, if anybody out there in viewing this as anti-immigrant, send an email to the court that's considering throwing people out of the country. And as long as your email gets sent there, that's due process for that immigrant. So instant due process. I just find it strange. I don't know. And now that I'm older than judges, I just start to wonder if, kids these days. And he also put his fingers in his ears and said, "La, la, la, I can't hear you," when it comes to where does the judge get the power. We have now just filed a motion for an injunction pending appeal with him literally minutes ago, where we are putting that question in front of him again. And I don't expect to win that because the thought of asking a judge, "Hey, would you mind issuing an order that says you were wrong and you're probably going to get overturned," is an act in futility. But you can't ask the appellate court for that until you ask the district court judge.
Yeah.
So here we are. So we are also. Oh, go ahead.
No, Mark, I wanted to ask you because Massachusetts seems to have something about buffer zones, right? Like this is not the first time buffer zones have happened in Massachusetts and the court has reviewed. In fact, I mean, I haven't been practicing law as long as you have, but I've been practicing law long enough to remember that in 2014, the Supreme Court struck down a 35-foot buffer zone around an abortion clinic in Massachusetts. So how does the court here justify a 200-foot buffer zone around a court complex that extends beyond the complex and onto traditional public forums like a sidewalk and a road?
I don't know. That's the thing. And if it makes no sense at all.
Yeah.
But here's the nice difference between those two cases. In the abortion clinic buffer zone, the legislature, which does have authority over that area, at least they had the authority to pass this law. Doesn't mean it comports with the First Amendment, but they have the authority. So then they did that. Now, in the legislative process, you have at least a semblance of due process, right? If you don't like the people who did it, you can vote them out. You can petition them. You can go up and lobby. So the people have some way to participate. Here, you got judicial fiat. Judge Canone says, "You own 200 feet around the courthouse." And then she even extended that further. How far can she go? Can she go all the way to Provincetown on Cape Cod? I mean, I guess everybody would say no, right? Can she go all the way up to the top of Mount Greylock out in Western Massachusetts? Probably not. But, I mean, you know the joke about where you talk to somebody at a bar, you say, "Hey, would you sleep with me for $100 million?" And she says, "For $100 million, sure." I said, "Well, how about for $1?" "Well, what kind of girl do you think I am?" We've established what kind of girl you are. Well, now we're haggling over price. Well, here, if you cannot extend it to the limits of the state border and beyond, I mean, why can't she issue it over the whole damn planet? I just, it doesn't make any sense. So where does her power end? I think any moron knows that a judge's power ends over at the courthouse steps. I mean, not when it comes to parties, obviously, or like in the abortion clinic case. See, it would make sense to say it to parties that are acting in concert with other people. But in the Commonwealth versus Reed, the Commonwealth that's what they call the state in Massachusetts. Well, I don't know what, there is no difference, but Massachusetts is very, very protective of this thing. We're the Commonwealth, not the state. So the Commonwealth and Karen Reed. Karen Reed isn't protesting. The Commonwealth isn't protesting. None of them are before them. None of them are in concert with them. Now, if the court had said, "I'm going to invite the protesters who I can see from my freaking window right here to come up and give their point of view," and she had given them 45 seconds to state their point of view, she might say there was due process. But there wasn't any. The country we live in requires respect for freedom of speech, respect for due process, and respect for limitations on government power.
That's right.
None of those are here. And, unfortunately, it has a little, although this should sound like it would transcend politics. An interesting side note of this case is it doesn't transcend politics. There's a very popular journalist in New England who goes by the moniker Turtle Boy. His real name is Aidan Kearney. And man, talk about an old fashioned style, just muckraking journalist. I mean, he's very opinionated, he's very biased, and he makes no apologies for that. He also happens to be, somewhat politically conservative. I would say extremely so for New England. So a lot of his fans are conservative because he's literally the only voice for them in New England. Every other media outlet in New England is, you know, definitely an appendage of the Democratic establishment. So it seems to have become right and left coded who you support in this matter. So all of a sudden, I got all this hate mail from people on the left saying, "Well, that's plenty of due process." And I'm just like, wow, that's kind of funny coming from you all. And look, I'm not politically reliable in any way. I'm in favor of the Constitution. I don't care who it makes angry.
That's right.
But you've got no due process here and no respect for the First Amendment. The Commonwealth's argument as to why this zone is necessary and proper. This is going to make anybody who pays attention to law fall out of their chair. The prosecution said it's going to negatively affect the defendant's Sixth Amendment right to a fair trial. When in the history of anything has the government said, "Gosh, this could make it harder for her to get off if people are out there." Now, also, they're liars because they're standing out there saying people protesting in favor of the defendant might negatively affect the defendant's right to a fair trial. And the defendant takes no position on this. The defendant's like, "Hey, not my circus, not my monkeys. People want to protest for me. Let them protest for me." So the Commonwealth's lying. Nobody should take that seriously, but they made that argument, and the judge pretextually bought it. But also, every single thing the Commonwealth brought to bear was about noise, saying, well, they have one juror that they said could hear the protesters inside the courthouse. Well, then you could narrowly tailor this restriction. You can say, all right, you can be out there, but you got to shut up. I think we still got a First Amendment problem there, but you pick and choose your battles. And I probably would not be out there going to court right now on on this case over just the right to be super loud in the street. then, but that's not part of it. It's just there will be no demonstration. So facially, this order is ridiculous and should be thrown out. But then now let's jump to how it's being applied. It's not just being applied to people standing there with signs, quietly not bothering anybody. It also is now being applied to journalists who want to stand there and take video footage. So the cops are not letting them do that because of the buffer zone. Now, why is that? Well, it's an as-applied challenge. And then Mr. Delgado, poor Mr. Delgado, who didn't do anything. He was just walking there. I wouldn't say walking down the street with a sticker on your jacket is protesting in the way that this order is supposed to be, ostensibly trying to prohibit. Although it doesn't define what a demonstration is. It bans demonstrations. It was so sloppily done, with such great glee to shut down dissent that, yeah, you could interpret it as saying you can't even walk through the area with a sticker on your jacket. But then the remedy is for the cops to say you're going to have to leave, or, hey, you're in contempt. Let's bring you up for a contempt hearing, even possibly arrest him. But you don't get to rip the thing off of his jacket. And I realize it's a de minimis deprivation of property, but still deprivation of property without due process. That thing that seems in short supply in Dedham, Massachusetts.
So, Mark, this reminds me so much of COVID, right? And so give me just a moment, because during the COVID pandemic, we had governors who locked Americans in their homes, right? They said, you can't go to church. You can't open your business. You also can't protest the very lockdown order that's keeping you in your home, the order you want to protest, right? The same thing is happening here, right? You have this idea of an emergency justifying the deprivation of a liberty interest. You have a judge who's issued an order prohibiting protest of her, right?
Yeah.
So you have protesters who have been out there for months criticizing this judge. This just seems like, the old Bill Murray movie Groundhog Day. Like, we've seen this before, and we just have to keep fighting, keep filing lawsuits, because it seems it's almost like human nature. Like, they're still going to lean on the side of violating individuals' rights unless we keep them at bay.
It's like a tin pot dictatorship, man. It's just crazy. And you are right. I mean, I brought challenges to COVID restrictions in Massachusetts and other states as well. But and it does seem that in Massachusetts, especially, and in the First Circuit, like I'm not handicapping our chances at the First Circuit as super high. The First Circuit is really got a problem limiting authority if somebody says it's inconvenient to limit authority. I mean, it's just wild. Like I had a case where the government shut down all video arcades in Massachusetts because of COVID. Now, I represented a bar called Bit Bar that sold drinks and food and had video games. So we had a Ms. Pac-Man table sitting there. And you could sit at that table and you could eat and drink. But as soon as you plugged that in and the video game came on, all of a sudden it was a problem. How does that make any sense? And we went to the legislature, we went to the governor, we went to the AG, and we were like, come on, just change this. No, absolutely not. There is a deadly pandemic in place and you can't play Pac-Man at the table while you eat tater tots. So we sued them. And then immediately upon serving them, they say, oh, okay, we changed our mind. You can do it. Now, there's a doctrine called voluntary cessation, which the government can't play hide and seek with the Constitution.
But they do.
But they do, and they did here. The First Circuit said, well, since they rescinded the order, it's no longer an issue. I said, hold on. The governor decrees a power to shut everything down. Then, since he gets sued, he undecrees it. And you're saying that he couldn't just decree it again the next day? He said, well, you have no evidence that he would do that. What do we need evidence he would do that for? All I need you to do is tell him he can't do that. And instead of telling him no, the courts are generally acting like, parents of really entitled, spoiled children We're not going to tell them no. We'll let it be everybody else's problem. Bing, I got knocked off my horse on that one. The first Karen Reed one knocked off my horse. I mean, look, man, maybe we're going to get knocked off here. I'm not, I am not ever going to say to people that I'm the kind of guy who has an even over 500 winning record. And it's not because I'm not damn good at what I do. It's because I will take the hard case that everybody else says you can't possibly win that, because for two reasons. One, I have taken those cases. I got a picture of St. Jude on my wall, who is the patron saint of hopeless causes. And once in a while, St. Jude's got, takes some time off from the little kids in the hospital and says, I got a spare minute for one of Randazza's cases. And we win them. And we advance the cause of individual liberty. Like when CAL backed us in the Berga case in the First Circuit. We did a lot of good with that, and we won that. So you might win. You definitely miss 100% of the shots you don't take. And, even if you don't win, I mean, I've brought cases before where I was trying to knock out Section 2A of the Trademark Act as unconstitutional. 25 cases I lost. And finally, there was a Supreme Court case that knocked that off. 1 in 25, but you only need that one.
That's right.
So, and you need people to stand up and say, F you. No, I'm not taking it lying down. I mean, if you get discouraged, and that's what they're trying to do, they're trying to grind people down who care about civil liberties with just the most ridiculous excuses and ways to let these people have unchecked power. And as long as there's like one person or one organization here that's willing to say no, they at least have to be kept that much honest. So I think it's worth it. Now, are we going to prevail at the First Circuit? Hey, I'm optimistic, but I also know how they operate. They're not going to look at somebody who politically agrees with them and give them a fair shake. But I think our briefing's a hell of a lot better than what the government puts in. So maybe we start a field goal down. We're just going to have to play that much harder.
Yeah. I think what's so important here is not even really the fact that this is involving Karen Reed. Like I don't have an opinion at this point of guilt or innocence, the underlying case at all, but I care deeply how the government reacts to people who do have an opinion, right? How they respond to expression that is supposed to be, publicly able to be publicly displayed without the government stepping in and suppressing it. So whether it's today, someone who is protesting the treatment of Karen Reed or the actions of this specific judge, what is it going to be tomorrow? And so I think that's, in First Amendment litigation, we have to think broadly. Like, this is about the principle of free speech, of free expression, the freedom of the press. That's another thing. I mean, probably don't have time to get into it in its depth today. But if the government can suppress the freedom of the press, then the government can control what information we're able to consume and ultimately control our actions as a result of what we're able to think. It's thought control.
That's what they want to do. I mean, could you imagine I keep bringing up these immigration cases because, I see those as kind of opposite coded. Imagine if an immigration judge said, you can't protest within 200 yards of 200 feet of this courthouse. Imagine the outcry. I mean, I really wish, I don't know. I wish I could find an immigration judge in Massachusetts willing to do that. And we see just how they look at that. Whatever rule, what federal judges seem to, I would say younger federal judges, the older ones from pre-filibuster getting thrown out. When you had to get 60 senators, you had to have some consensus. I think you had judges with more of a broad view of what their position entailed. And when you get them post filibuster, where they're just, they push them through in a state like Massachusetts, where Elizabeth Warren's going to blue slip anybody who's not, to the left of Bernie Sanders. And you get the same problem in other states where a Republican senator is going to blue slip anybody, that's not to the right of, Alex Jones. You wind up with this weird split country where it matters more where the violation happens than what the violation is. And I think they all have this myopic view of, Your Honor, what's going to happen when it's protests that you like? And your very order is the precedent upon which they rely in order to suppress it. and every one of them thinks, not my problem. And I think, my favorite, one of my favorite scenes in Saving Private Ryan, well, my favorite scene is if you've seen the movie, when they're walking past, there's this machine gun nest. Their mission is to go find Private Ryan, and Tom Hanks's character says, we're not leaving that for the next guy. This is what I love about doing this work and doing work with CAL, is CAL doesn't leave the machine gun nest for the next guy. And that's what we're doing here. We're not leaving this for the next guy. Maybe we're going to fail, but you know what? Even if we fail, we won by fighting. Because when somebody one day looks back and says, why didn't somebody do something about this at the time? I at least, even if we lose resoundingly, I'm at least very proud of the fact that they're going to look at that and go, these two guys, Marc Randazza and Marc Trammell, tried to do something about it. And that's, sometimes that's good enough.
Yeah. Well, we're gonna hope for a win. I'm hopeful and confident, Marc, and goodness, Center for American Liberty. We're so grateful for your leadership on this, for your advocacy on behalf of protesters and journalists, and your courage to stand up to a judge. That's not a small feat. And so we're really grateful, Marc.
Well, let's
for all
not
that
forget
you're doing.
your name's on those pleadings too. You're right there next to me, so don't forget to pat yourself on the back.
Well, thank you. Anyone watching this, again, it's not a podcast, not a show. Like, if you're watching this video thing on social media and you want to support the case, you're welcome to do so. We invite you. We need your support. You can go on www.libertycenter.org and make a donation today. Marc, thanks so much. We appreciate your time.
It's my pleasure. Thanks, man.